It's Guy DiMartino, a Northwest Indiana estate planning attorney. If you have any questions about an estate planning or probate matter, you can always set an appointment with me at indianaestatemeeting.com. Today, I'd like to talk about probably one of the most important estate planning documents that somebody can have within their sixth decade. And I'm getting there pretty soon. I'm on the north side of my fifth decade, and I've had to deal with this with my parents who are in their eighth decade of life. And this most important document is a power of attorney. You know, if you're married and everything is jointly held and you have everything in line along those lines, a power of attorney is not as important. But if you are single, or you are a widow or a widower, even if you have somebody that you're in a significant relationship with, you need a power of attorney. What a power of attorney is, it's a contract between you, the principal, and the person that you name as your power of attorney that can act on your behalf. Now, when can they act on your behalf? That depends upon the terms that when you make the power of attorney effective. Most folks will make the power of attorney effective if they become physically or mentally incompetent or disabled. So for instance, say you go in to the hospital and you have a procedure and things do not go as well as you hoped, and then you have to go into a rehab facility or you're not able to handle your financial affairs. If you have somebody who is your power of attorney, that person can go ahead and handle your financial affairs while you're in the rehab facility. What happens if you start to lose your mental function and you start to get some dementia, and the dementia gets to a point where you really can't handle your own affairs? If you have a power of attorney and you have the proper language in your power of attorney, then your power of attorney can handle your affairs. You see, if your power of attorney and you don't have one, and you are mentally incompetent, it's going to require somebody to go to the court and file a petition for a guardianship. And that can be a whole bunch of expense. You might have to bring doctors into court. It can cause a dispute, and it can cause a lot of money and a lot of heartache, and it can cause just a whole waste of time and needless energy on behalf of other folks. You see, if you're mentally incompetent and you have to go into an assisted living facility or a nursing home, you do not have the mental capacity to sign the contract. So if you have a power of attorney, your power of attorney can sign the contract for the ALF, assisted living, or the nursing home. And if there is no power of attorney, then somebody might have to petition the court for guardianship over you, either your person or your estate, and both. So then that person, your guardian, can go ahead and sign the documents that you need to get into the assisted living or the nursing home. So there you have it. As you get older, especially be discerning in who you are going to name as your attorney in fact or your agent. If you have any questions about an Indiana estate planning matter, you can always give me a call or set an appointment at indianaestatemeeting.com. Have yourself a great day.